And as I was about to embark on a demonstration around consistency, Secretary of State's position.
Yes.
Just before I do that, over the break, I've had an opportunity to reflect on my Lord Justice Singh's question earlier on about whether we need any more for the ratification of the Paris Agreement. If I may just come back to that very briefly. Ordinarily, we say absolutely not. That is sufficient to indicate that something is a matter of government policy. But if we look across to another jurisdiction, across the Atlantic, we have an example there of how it may not be sufficient, because we had one executive that signed and through executive order adopted the Paris Agreement, and then the replacement executive comes from a different policy position and expressly distances themselves from that agreement, but because of the mechanics of the Paris Agreement, they're not able to formally withdraw until 2020. So you do there have an example of it being conceivable, at least, to have ratified something, but there being a question about it, whether it reflected the policy of the current executive. And so for belt and braces purposes, my lords, that's why we say the abundant evidence of the proactive action taken by this government to implement the Paris Agreement into law is an important part of the submission.
Yes. Yes.
My lords, can I turn you please to the core bundle, volume 3, tab 9, 1501. These are the defendants' amended detailed grounds for contesting the claim in the court below. The amendments are in red, and they allow us to see the original grounds for contesting the claim.
I think I may have the wrong reference. I don't have the amended detailed grounds. Which page did you say?
So it's volume 3 of the core bundle.
Yes, I have that.
Tab 9.
Yep, I have that.
And it should be page 1501.
1501, sorry. I had yet to get to that. Thank you very much.
And for the moment, my lords, I'm going to ask you to ignore the red text. It's the original version that we're interested in. Come to paragraph 9. See what's said there. First, a key aspect of the claim is the Secretary of State's alleged failure to take into account the targets set in the Paris Agreement. It's not being admitted that the Paris Agreement wasn't taken into account. Goes on to say, however, the Paris Agreement was raised by respondents to the consultation, and it was considered, for example, in the government response to the consultations on the airport's national policy statement. And below, in some of the text at 8:19, this is a passage taken from the government's response. There's a reference to the Paris Agreement. There's a reference to pursuing the goal of the Paris Agreement, albeit it's been misstated. Then if we move on to paragraph 24 of the grounds. Furthermore, the Secretary of State considered the Paris Agreement in producing the ANPS and explained his position, e.g. in the consultation response. So here we go beyond simply not admitting the allegation. We have positive denial. And my lords, because both perhaps I shouldn't speak for Friends of the Earth, but certainly both Friends of the Earth and Plan B made applications to the court for disclosure, because our position was, well, that'd be interesting to know, what material the Secretary of State looked at that led him to believe the ANPS was consistent with the Paris Agreement. That seemed a very implausible position to be taking, so we'd like to know what material he's relied on. And at that stage, we had a pre-trial hearing in January, and Mr. Marici said, well, this is all completely unnecessary, because actually there's a simple question of law here. Was the Secretary of State required to consider the Paris Agreement, in which case we lose? Or was he not? In which case we win. So really we can't understand why we need this evidence about what the implications of the Paris Agreement were. And Plan B said, well, this is very strange, because that's not what your pleadings say. Your pleadings say you did consider it, and we want to understand what material you took into account. And Mr. Justice Holgate, who was presiding over that hearing, he took that point. And Mr. Marici said, yes, well, there's an inconsistency there. Or maybe that's not what he said, I forgive. There's a need for clarification. We will clarify, make it clear that the Secretary of State's position was that he did not take the Paris Agreement into account. And on that basis, our applications for disclosure were rejected. We didn't get that clarification in writing initially. And Plan B then complained to Mr. Justice Holgate and said, well, we've had our application for disclosure rejected on the basis we were going to get a clear concession that the Secretary of State didn't take into account the Paris Agreement. We haven't had that, so we've not had our application for disclosure considered, and we're still faced with pleadings that claim that the Paris Agreement was taken into account. My Lords, may I take you now to Plan B's supplementary bundle, tab 379. Here you'll see the response from Mr. Justice Holgate through his clerk, Jonathan Willis. And it says, Judge has read the exchange of emails. His recollection of what occurred at the PTR is broadly along the lines recounted in the letter from Mr. Crosland. The defendant's concession, or rather helpful narrowing of the issues, arose in the context of submissions regarding the applications for disclosure. A principle by submission by the defendant was that once the real issue under the grounds of challenge were correctly defined, then the disclosure sought was unnecessary. Then if we come a little bit further down to the fourth paragraph of this email, the defendant appears to be seeking to draft the concession in language materially different from that used in the position statement and from what was said at the PTR, and without explaining so far to the court why he has sought to do this. And if you just turn over the page, page 80, the court therefore directs the defendant to reconsider his position on these issues today. My Lords, if we go back now to the core bundle, volume 3, line 1501, points in red then follow that exchange. We go to back to paragraph 9. This is where, in the original version, it's a reference to the alleged failure to take Paris into account. We go to paragraph 10. There's a bit there in black that was part of the defendant's original submissions. The claimant inexplicably omits even to mention this. In other words, the original stance taken by the Secretary of State is it's quite extraordinary that Plan B are making this allegation that we didn't take the Paris Agreement into account when there's clear evidence that we did. In the consultation response, simply inexplicable. Following the amendments, for the avoidance of doubt, the above matters confirm that the Secretary of State and his officials did not ignore the Paris Agreement, or that there would be emerging material within government, evidencing developing thinking on its implications, but it was concluded that such material should not be taken into account, i.e. it was not relevant.
I was also called to read on.
Yes.
My Lord says...
So what was the position before the Divisional Court in argument?
that it was not relevant. So that this remained the position.
Not relevant and not taken into account.
Other than to determine that it was not relevant. It was taken into account only to determine that it was not a relevant consideration. That was the formula. And my lords, when we say there's, it's for the purposes of these proceedings, the Secretary of State adopts the position that he does. There's a further oddity, and you'll see that at page tab 3, page 74 of our supplementary bundle. And this is a document headed International Aviation and the Paris Agreement Temperature Goals. And it's published by the Secretary of State in December 2018, so some 6 months after the designation of the ANPS. And it's published as part of a consultation on developing the UK's aviation strategy. And this document says, for the Paris Agreement's goals to be met, this is the second paragraph under the summary, large reductions in global greenhouse gas emissions are required. Move down 2 paragraphs, the first sentence, the Paris Agreement is a temperature-based target and therefore implies inclusion of all emissions that affect climate. Aviation has significant non-CO2 climate impacts from oxides of nitrogen. And then to the last paragraph on the page. Therefore, for 1.5 degree global scenarios, any continued emissions of CO2 from aviation using fossil fuels beyond around 2050 will be inconsistent with the Paris Agreement goals.
Sorry, what did you say was the date of this document?
This is published in December 2018, so it's published after the designation of the ANPS. We don't know what date it was commissioned, but it must have been commissioned before December.
It was commissioned by the Department of Transport.
Indeed. So, my lords, we simply ask that the court reflects on lack of certainty about the Secretary of State's position over time. During the consultation process, as he himself pointed out in his initial pleadings, there was evidence that he had taken account of the Paris Agreement and did consider it to be relevant. In June 2018, when he designated the ANPS, it had become a non-relevant consideration. In November 2018, when he first drafted his grounds of resistance, it was a relevant consideration. In December 2018, when he published the document we've just looked at, it was a relevant consideration. In January 2019, at the pre-trial review, it had become an irrelevant consideration again. And my lords, we say that this doesn't simply go to the credibility of the Secretary of State's position. It's material in relation to our ground 4. We say if the Secretary of State's own legal team were confused by the Secretary of State's position, and in November 2018 considered that he had taken the Paris Agreement into account, well, what about all the consultees? What about Parliament? Was it not equally likely that they too would have been confused by the position and under the impression that the Secretary of State had given due account and due regard to the Paris Agreement and our obligations arising under it? And my lords, despite the court below's intimate involvement in that history, we say it is a remarkable thing that it is simply whitewashed out of the judgment in the court below. There is simply no reference to the changes of position in the judgment below, despite the emphasis that we unsurprisingly place on it.
Yes.
My lords, moving on to the dispute between the parties as it now is, as it's been defined in current pleadings, critical to our case to be clear that we accept entirely that the Climate Change Act, Section 1, and the at least minimum target of 80% reductions by 2050, we accept and have always accepted that was part of government policy on climate change. Our case is that it only imposes a minimum requirement, an at least requirement, and so there's nothing inconsistent at all with reading that in conjunction with other commitments that demand more stringent ambition in light of developments in the science. That is our position. Both the Secretary of State and the court below, we say, proceed on the false assumption that the Climate Change Act Section 1, as it then was, is the exclusive determinant of government policy. Broadly, they both approach it on the same two bases. They say, as a judgment, paragraph 606 to 7, where we see this repeated emphasis on the Paris Agreement not being binding on domestic courts and the UK being a dualist system. We've already covered that point. We said that's simply a straw man argument. We've never suggested any different, just not part of our case. And really, the only other substantive point we say is that we find at paragraph 615 of the judgment below, this is where the court below says that if I may summarise first of all, by seeking to suggest that the Paris Agreement and the commitment to a net zero target should have been taken into account as well, we were effectively seeking to undermine the statute. The wording is, despite the fact that government policy could of course be outside any statutory provisions, neither policy nor international agreement can override a statute. Mr. Crosland's expressed an unequivocal concession that the carbon target in CCA 2008 as government policy was a material consideration for the purposes of the AMPS. Submission seeks collaterally to undermine the statutory provisions. My lords, we just don't understand that position. First of all, and this is a point we've already made, if section 5.8 was intended to constrict the analysis to the Climate Change Act section 1, that is what it would have said. It would have been an easy thing to do. But the terms of the provision, at least, and the setting of a minimum target in a context where everybody knows and Parliament knew the science was developing rapidly, seems very clearly designed to allow for greater ambition.
So, in a simple way of putting it, it would be that there is nothing incompatible between policy embodied in section 1 of the Climate Change Act on the one hand, and maturing policy embodied in the Paris Agreement on the other.
Exactly so.
Indeed, the two are complementary.
Entirely complementary. We said that was the purpose of the provision. It was written that way with good reason, because Parliament understood we were facing a rapidly changing picture. You needed that sort of flexibility. People understood that the likelihood was that targets would only ever move in one direction for a whole host of reasons. My Lords, Secretary of State and the Court below place great emphasis, and we say with very good reason, on the opinion of the Committee of Climate Change. That is the independent body, the statutory advisor to the government, and both the government and this court should quite properly place great emphasis on the committee's opinion. I may turn the court to our supplementary bundle, tab 2, page 50. This is a report from the Committee for Climate Change from January 2018. And on page 50, under the heading Preparing for 2050, the second sentence begins, however, the Paris Agreement is likely to require greater ambition by 2050 and for emissions to reach net zero at some point in the second half of the century. It is therefore essential that actions are taken now to enable these deeper reductions to be achieved. And we say that the committee's meaning there is quite plain. It's saying, we know there's some statutory machinery that means it may be a little time before the target is changed in law, but we know it's coming. And so we've got to be planning in a way that leaves that flexibility to go further. Otherwise we end up shutting the stable door after the horse has bolted. my lords, we say that consideration should have been prominent in the Secretary of State's mind in the context of a project of the scale and significance of the one we're considering, locking in emissions potentially for decades. Neither the Secretary of State nor the court below make any attempt to explain that passage. They rely on various other passages from the Committee on Climate Change. They just don't address that. And if we may now, if I may turn, my lords, to page 68 of the bundle.
Yes.
Rather extraordinary act for the statutory committee. Following the Secretary of State's statement in the House, the committee wrote a public letter on the 14th of June 2018. And in our submission for a statutory committee, this is quite a strongly worded letter in a highly charged political context. Begins by saying, Dear Secretary of State, the UK has a legally binding commitment to reduce greenhouse gas emissions under the Climate Change Act. The government has also committed, through the Paris Agreement, to limit the rise in global temperature to well below 2 degrees C and to pursue efforts to limit it to 1.5 degrees C. We were surprised that your statement to the House of Commons on the National Policy Statement on 5th of June 2018 made no mention of either of these commitments. It is essential that aviation's place in the overall strategy for UK emissions reduction is considered and planned fully by your department. The committee goes on to emphasise the target under the Climate Change Act, and whether we call it the aviation target or the planning assumption. They talk about that already being at the limit of what is feasible, the strain that imposes on other sectors of the economy, the space that emissions from aviation are taking up. And on page 69, as the letter comes to its conclusion, they invoke the Airports Commission. They say that it also incorporated the CCC's advice on aviation, and it concluded that any change to the UK's aviation capacity would have to take place in the context of global climate change and the UK's policy obligations in this area. So that, we say, is the Committee on Climate Change being invoked by the Secretary of State, coming out and in quite forceful terms expressing concern about the lack of emphasis being given to climate change generally, but specifically to the Paris Agreement.
Can I just ask you to read the penultimate paragraph of that page as well, before you look forward to?
Yes.
My Lords, indeed, yes. This is a reference to the Department's new aviation strategy in 2019. And there it seems that the committee's warnings were heeded, as it were, because that's where we see that document we've just looked at, the Secretary of State publishing a statement about aviation and the Paris Agreement. And if we turn over the page 70 of the same bundle, this is Mr. Grayling's response to Lord Deben and Baroness Brown from the Committee on Climate Change. He expresses thanks for the letter. In the second paragraph, he says, I hope you will understand I'm not always able to include all the detail I would like in an oral statement. The one thing he doesn't do my lords, in this letter is say, Lord Deben, you've got it wrong here. Actually, the Paris Agreement isn't a relevant test. It's not a relevant consideration in the AMPS. We should be using the historic 2-degree target. My lords, if that's genuinely the Secretary of State's position, he should have made it clear so it could have been scrutinised and everyone could have understood that the AMPS had been tested against the old, discredited, historic 2-degree target that the government considers dangerous to its residents. So, my lords, that in summary is why we say it does not assist either the Secretary of State or the court below to pray and aid the position of the Committee on Climate Change. The Committee on Climate Change's position is, we say, entirely consistent with ours. You need to consider both the Climate Change Act's target as it was in June 2018 and consider it alongside the Paris Agreement. That was quite clearly and explicitly the position of the Climate Change Committee. My lords, just a small point on this issue, just a concluding point. Mr. Marucci is completely entitled, and why wouldn't he, to point out the difference between Plan B's position on Section 5.8 and that of Friends of the Earth. There is that difference, we acknowledge it.
Well, we've got to decide what the law is.
Indeed, sir.
And although it's helpful to know what different parties' positions are,
Indeed.
we've got to say what the law is.
Of course. And just simply for the record, we'd like it recorded because it wasn't in the court below that the position of the other claimants, including the Mayor of London, including Greenpeace and the Boroughs, explicitly in their skeleton argument was to support our interpretation of Section 5.8.
Could you be clear? I'm sorry, forgive me. Could you be clear? It's obviously a matter of record. Could you be clear as to which parties did associate themselves with your argument?
So this, you'll find this, my lords, in the core bundle, volume 2,
Thank you.
tab 7, 886. And this is the Borough's skeleton argument in the court below. And at paragraph 96.1, you'll see it said on behalf of all 7 of the claimants in the Borough case. We support the submission that the Paris Agreement is a key aspect of government policy.
So that was the borough's position aligned with yours.
Indeed, sir.
Yes.
It was in his skeleton argument. Mr. Marucci says that we ought not now to invoke the government's commitment to a net zero target, as this wasn't clear in our submissions below. Guided by the court, I mean, we say it's a matter of record that was there in our submissions below. I can guide you to the relevant passages. This has always been part of our case, but within this broad framing, the key thing is ratification of the Paris Agreement.
Okay.
The commitment to a net zero target is evidence of that commitment. That's the way we put it.
You say it's inherent in that commitment.
Indeed so.
We have your skeleton argument in the court below, don't we?
You do, my lords. And just to make it clear, there's a passage in there from the transcript. Find this on page tab 384 of our supplementary bundle.
Just a moment. Tab 370. Which page?
Page 84.
84, thank you.
And you'll see under the page heading 110, there's a break in the page.
Yes.
You go to the second paragraph, and these were our submissions. What the committee urged the Secretary of State to do was to consider both the climate change target under the CCA and the Paris Agreement. It goes back to the position they set out so clearly in 2016, where they say now is not the right time to make the changes. We need the evidence from the IPCC. But in the meantime, we know that change is coming. We know that government has already committed to a net zero target in light of the Paris Agreement. We know the 2050 target is likely to require amendment. So what we have to do is maintain flexibility to go further, because otherwise we end up shutting the stable door after the horse is bolted. So, my lords, the risk of repetition, the point of the repetition is just to be clear that we were making the same submissions in the court below, despite what my learned friend for the Secretary of State put in his skeleton argument. This is nothing new. And likewise, my learned friend puts emphasis on the government's position in the previous Plan B case around the carbon target, where our position was, you're taking too long. Paris was a long time ago now. Where is the change in the law? The defendant's position in that case was to say, we're fully committed to a change. We've told you we're committed to change. You can't tell us when to do it. So actually, the Secretary of State's position there, in pleadings before the court below, was to emphasise that government commitment to a net zero target.
Do we have a transcript of that too?
My lords, that is tab 125 of our supplementary bundle. So these are the pleadings to the Secretary of State for Bays.
Yes.
And if I take you to paragraph 29, see, they're resisting the proposition, our proposition at the time. They weren't taking the Paris Agreement seriously enough. They say the government is fully committed to enshrining the goal of net zero emissions in domestic law.
I think what would be said against you is that that's consistent with the Secretary of State's stance in the present case, because their fundamental submission, as I understand it, is that yes, they do have, at the material time they did have that commitment, but it was precisely to enshrine the goal in domestic law in due course. And that's what's happened, but it happened after the ANPS under challenge.
Indeed, but we say that was the policy commitments that's prior to the change to legislation. And then we have the guidance from the Committee on Climate Change. It says because we know that change is coming, we need to retain the flexibility to go further. Otherwise, we precluded our options as we shut them down.
Well, you say, don't you, that the policy, this policy, existed at least from the moment of the entering into of the Paris Agreement.
We do. But it hardens from March 2016 when you get these very express statements
Yeah.
from the government saying we're going to be acting, just give us a bit of time to work it out.
Yes, forgive me, Mr. Cross. And I just want to be clear. I understand the submission because there are a lot of arguments, and I'm not complaining at all. It's all very helpful, and it's all very important. But I just want to focus on what exactly is being said under this ground of appeal. You don't. I don't think you need to say they had a commitment to achieve anything. What you do say is that they did have an obligation to take Paris into account, and they didn't do it.
Indeed,
And that's the fundamental public law error. You say that's the end of the case. That vitiates the ANPS. If you're right.
We do say that. All this other stuff is subordinate to that main point.
Yeah, I just wanted to be clear that I understood that.
That's absolutely the heart of
Because
the
obviously, I do understand there are lots of people on both sides of the debate. Lots of people want to see particular outcomes. They want to see particular targets enshrined in law. What the government was saying was, we're committed to enshrining it in law in due course. And they will say, we haven't done anything inconsistent with that. But your fundamental point is that whatever might happen at some point in the future, at the material date, your policy was that you are committed to Paris. And if you then say, we're going to ignore it because it's not relevant, that's a public law error which vitiates the entire decision-making process. Now, you may be wrong about that, and we'll have to consider that. But isn't that the fundamental submission?
Point, indeed it is. That is the fundamental point. Move on to a related but a distinct point, which is the Secretary of State taking into account the 2-degree target that was not in fact set out in the Climate Change Act. This was, as all parties agreed, back in 2008. The political consensus was limiting global warming to 2 degrees would be sufficient. That was the judgment at the time, and so it was on that basis that the Climate Change Act was enacted. But it's not in the Act itself. In 2018, 3 years had gone by since that 2-degree target had been discredited, and we've seen the reasons for that in the government's Clean Growth Strategy, where they explain the science and the intolerable risks inherent in allowing warming to get to 2 degrees. What the Secretary of State and the court below now seem to say, though we say this is obscure and unclear, why the 2-degree target was independent of the Climate Change Act a relevant consideration, is that since that was the basis of the 2008 Act, to use the Paris Agreement target, that more ambitious target, would be the same mistake that they're making again. It would be to undermine the statutory regime. My lords, we say that is completely wrong and misguided. We say it's like, imagine, maybe this isn't the most apt example, but a Medicines Act where there's legislation and as part of the regulatory regime, certain medicines are listed as being safe. And then emerging science shows that in fact one of those medicines is not safe at all, it's very dangerous. And in court we say, well, why are you prescribing this this, 'This, 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 ' we're still working to that existing Medicines Act, and it would be to undermine that act to say that this medicine was unsafe. We say that's complete nonsense. In 2018, everybody knew the 2-degree target was dangerous. The fact that that may have been the basis of the target setting in 2008, we say can't possibly justify using it as a benchmark in 2018. It's a dangerous benchmark. And we say that error is compounded by the fact that nowhere in this extensive consultation process, and Mr. Marici rightly points out, well, court should be slow to interfere. Look at all the documents, look at all the reviews and eminent people who've looked at this beforehand. Nowhere in any of that documentation is there any allusion to or any reference to the Secretary of State having used the discredited 2-degree target as his benchmark for assessing the viability of the AMPS. That only emerged through these legal proceedings and through the disclosure of the Secretary of State's witness statements.
Yes.
And my lords, that really brings us to our fourth ground of appeal, which is that the court erred in treating as irrelevant the Secretary of State's failure to explain to Parliament and others the basis of his decision.
Yes.
Again, the Secretary of State says that we shouldn't be allowed to argue this because we didn't argue it in the court below. We say that's just factually not correct. What is correct is initially in our pleaded claim we didn't make this point because at that point we didn't know and nobody knew that the Secretary of State had considered the Paris Agreement to be irrelevant and that the 2-degree target was relevant. But once that issue came to light and we had this volte-face from the Secretary of State, having said it was relevant, then saying it wasn't, that became a prominent part of our case. And if I can take the court to tab 385 of our supplementary bundle. Again, this is part of the transcript from the court below. We say the fundamental point, my lords, is that the position that the Secretary of State now advances that the Paris Agreement is irrelevant was new to these legal proceedings in January. It was not his original position, and it was not his position as set out in the AMPS. That gives him the basic problem that the reasons he gave in the AMPS originally under Section 5.8 that did not state that the Paris Agreement was irrelevant, but gave every impression that international obligations had been considered. These are not the reasons he now gives to the court. So they can't both be right. The way in which he exercised his duty to give reasons under Section 5 of the Act and his position in this court, they're different. So one of them's not right, say just as a matter of logic. Let's go back to tab 262 of the bundle. This is the is the government response to the consultation process, and we've already considered these passages a little bit earlier in the context of.
I'm so sorry, Mr. Constable. Which page is it?
This is page 62. My lord.
Oh, I must have the wrong. Which volume did you say?
So it's Plan B supplementary bundle,
Forgive me, I'm in the wrong volume.
and tab 2, page 62.
Thank you. Yes, and which paragraph?
818.
Thank you.
And this begins, the government notes the concerns raised about the impact of expansion on the UK's ability to meet its climate change commitments. The government has a number of international and domestic obligations to limit carbon emissions. Looked at this earlier. And we say that's a clear indication to people reading this, or certainly an implication, that the Secretary of State was mindful of international obligations, which for most people would mean the Paris Agreement.
I'm sorry, what's this taken from?
This is the government response to the consultation on the ANPS.
Yes.
And then, my lords, in the following paragraph, and
I'm sorry, the point you draw from 818 is what exactly?
the reference to international obligations
Yes.
would imply to most people that the Secretary of State was being mindful of both domestic obligations and international obligations.
The trouble is, the very next sentence says the UK's obligations on greenhouse gas emissions are set out under the Climate Change Act 2008.
My lord, indeed, it is. There's some incoherence there. It is confusing, we say, because first he says both and then he hones in on the Climate Change Act. But then we get paragraph 819. And here there's explicit reference to the 2015 Paris Climate Agreement. This is 5 lines from the bottom of page 62. And he talks about an important contribution from this sector to meeting the Paris Climate Agreement temperature limit. So what we say, my lords, is the ordinary reader of this document would infer from these passages that the Paris Agreement had been taken into account. They might stop and pause and think, well, there's a slight oddity in paragraph 818 because he refers just to the Climate Change Act, but the net effect of reading those passages is that international obligations in the Paris Agreement has been considered.
Yes, just going back to 818, the first sentence, which refers to the government having a number of international and domestic obligations. What other international obligations beyond the Paris Agreement would be relevant here, or might be?
Well, there's reference to Corsia, which is an international arrangement on aviation. It's not clear. It could be various things. There are other potentially relevant instruments, but for most people and for the ordinary reader, international obligations in climate change means the Paris Agreement. It's just the first thing that would come to people's heads. So it's not our submission that there is nothing else it could conceivably be.
No, but you read the two paragraphs together and you say that when you do that, the salient international obligation is Paris Agreement.
Indeed. And we also say that should be read in the context of some of the other documents to which we've already referred the court, for example, the Clean Growth Strategy, where we get that repeated emphasis on the Paris Agreement from the Prime Minister, from the Secretary of State, in the executive summary. We say this just needs to be looked at in context.
Yes.
You say, presumably, that there's a strong, consistent theme running through all these statements, which is to the same effect, that Paris will be implemented.
Indeed so. On that theme, my lords, government policy is not simply confined in this area to what happens domestically. Go to 253 of our supplementary bundle.
Page 53.
Yes.
Yeah.
So this is a green future, the government's 25-year plan
Yes.
to improve the environment.
Yeah.
This is also published in January 2018. There's a sort of flurry of activity in January 2018. Turn over the page to page 54. And the last paragraph just before that box, actions we will take. Using our leading role in the UNFCCC, which is the convention that introduced the Paris Agreement, through which the Paris Agreement was established, we will urge the international community to meet the goals enshrined in the text, in particular as a first step through securing robust and integral rules and standards. This is vital for future environmental security. Current global commitments under the agreement are insufficient to limit average temperature rise to well below 2 degrees C.
I missed the date of this document.
This is January 2018, so it's before the ANPS, before the designation.
Yeah.
And on a similar theme, my lords, page 55, the facing page in the bundle. You see here is a question to the Foreign Office Minister Mark Field. What diplomatic steps his department has taken to support the implementation of the Paris Agreement on climate change? And the response, this is March 2018. Climate change is an existential threat, but also an opportunity to drive a global clean economy revolution. Our diplomats and climate envoy are working with BEIs and international partners to ensure international implementation of Paris Agreement commitments and project UK leadership.
This is really about something different, though, isn't it? This is about foreign relations.
Well, it is, but we say that this is part of UK government policy, is to recognise this as a global problem, and that you can only solve it in collaboration and partnership with other countries. So therefore, part of policy, part of government policy, is to set a good example. Because otherwise, how are you going to influence others? And so we say this is also part of the context here. Government telling everybody, we're going to lead the way, we're going to show through our commitment to the Paris Agreement goals that this is the way for others to follow.
On the opposite page, it refers to clean growth strategy. Is strategy part of policy, i.e. the implementation part of it? We've got a strategy for implementing our policy.
My lords, yes, may well be that way round. I mean, they interact. We say, and I think the Secretary of State concedes that the Clean Growth Strategy, which is in fact published under the legislation, under the Climate Change Act, is part of government policy. That is a good example of a policy document in climate change. And so we come back, if I may, to this point that taken in context, when the people who are focused on this subject are reading about all of this and reading about the efforts that the UK is taking internationally and diplomatically to influence others, and they read a report from the Secretary of State that says we're mindful of our international obligations, and this is the Paris Agreement. Well, naturally, this is what people are going to assume he's referring to. So that was the reason for that little detour.
Yes.
My lords, those are the main substance of our submissions on our grounds. There are various points, or a handful of points, that the Secretary of State has raised in his skeleton arguments, which, if I may, I'd like to address now. There's good use of time.
Yes. I mean, there may be some points that you could leave to reply, I imagine.
That may not be
which
the
would be
case.
the
Yes.
conventional way of responding. But it may. We'll be generous. You've your time doesn't run out until 3:15. So if you've got points, bearing in mind your opportunity to reply in due course.
I'll just deal with them very quickly.
Just bring out the points that you feel ought to be brought out now.
There's a suggestion from the Secretary of State that because there is now a process of review under Section 6 of the Planning Act, in light of the developments, that's subject to following a letter from Plan B, but also one of the other parties in this case asked for a review in light of developments, that that renders these proceedings academic. We say not so. There's a fundamental difference in the approach to a review under Section 6 to the process for designating the ANPS. If the process for designating the ANPS was flawed, that can't be cured by a process of review. The obvious point being, if that were the case, you could just bypass Parliament, which is not the intention of the statutory scheme as a whole. We also say that all that has happened is, back in May, we asked for a review. And all that the Secretary of State has done is send us a letter that says we may consider that position. And we're now 5 months on, and part of the context was Parliament's declaration of a state of climate and environmental emergency on the 1st of May. So we say, well, first of all, it wouldn't render these proceedings academic, even if the Secretary of State had agreed to conduct a review, but he hasn't. We've just sent a letter. How can that change the dynamics of these proceedings? The Secretary of State says in his skeleton argument that Plan B has not addressed the economic arguments in favour of expansion. Primarily, that's because that's just not part of our case. Our case is a point of law. It's not about the economic arguments. But because he raised that in the court below, we addressed it in the court below. And if I may draw the court's attention to tab 381, the right supplementary bundle. And 2 paragraphs before the page break, 104 of the transcript, we say, my Lord's Plan B has no position on aviation other than that it should be consistent with the government's policy on climate change. In relation to the claimed economic benefits of the ANPS, the only reason we've said nothing about them is because they've not been relevant to the issues. But since Mr. Marici raises the point, I ask my Lords to recall the evidence we referred to last Wednesday from some of the country's leading economists, including Lord Stern, formerly Chief Economist of the World Bank, Mark Carney, the Governor of the Bank of England, both of whom emphasised the grave risks to the economy if climate change is not contained to agreed limits. And we then go on to say, it is clear that such risks and costs of adapting to climate change generally were not considered by the Secretary of State in the course of this assessment, and unless and until the climate change impacts are properly addressed in accordance with the Act, including in relation to adaptation, and until the words of the Governor of the Bank of England are taken into account, the claimed economic benefits in our submission must be treated with some caution. My Lords, we only make this point because the Secretary of State has said we don't address the economic argument, and that's just factually not correct. And finally, my Lords, a point raised by the first interested party, say that even if our arguments were to be accepted, it is not properly arguable that having regard to those factors could have made any difference to the outcome. Well, we don't agree with that. We say the Secretary of State didn't take into account the Paris Agreement. Had he done so, the answer would have been very different. But we make another point as well. The first interested party was in court during the pre-trial review when we made our application for disclosure of information about what Paris implied, and that application was rejected, and the Secretary of State agreed he wouldn't take a point on the discretionary argument, and the first interested party said nothing. So we say we're now in a position where we don't have the information that we might have had, and the first interested party is raising a discretionary argument and saying it wouldn't have made any difference. So we say procedurally there's something about that that doesn't feel quite right, but it's a subsidiary point. Our main point is it would be impossible for this court to say that had the Secretary of State considered the appropriate temperature limit, the Paris Agreement temperature limit, the outcome would have been the same. Net zero emissions by 2050 is a very different thing from 80% reductions by 2050. On the face of it, the projections we have from the Department of Transport that they could conceivably get close to that planning assumption of 37 megatons of emissions from aviation by 2050. On the face of it, it's hard to stack that up with net zero emissions by 2050. My Lords, those are our submissions, unless there's anything I can assist you with.
Thank you very much, Mr. Crosby. Yes, Mr. Reed.
Well, in terms of the structure of my submissions,
Yes.
4 headings. I'm going to start with some matters that constitute an overarching response on behalf of the Secretary of State
Yes.
to all the climate change issues that have been raised by both Friends of the Earth and Plan B. And I anticipate that will probably take me most of the rest of the time I've got this afternoon, that
Yes.
first heading.
Yes,
Well,
we're going to stop promptly at 4:30
4:30.
Today because Lady Justice Hallett's valedictory is taking place at 4:45, so we need to rise promptly at the normal finishing time today.
Mr. Muddle, I will certainly hope to finish this first heading by then. But I'm not asking you, certainly, I'm not asking you to sit any later. Well, secondly, once I've done that, probably tomorrow morning, I'll turn to deal with Friends of the Earth's 3 grounds of appeal, A, B and C.
Yes.
But my lords, you'll know that on ground A, for example, there were 8 sub-grounds pursued in grounds of appeal.
Yes.
So A1 to A8. My lords, in my submission, the reality is we only need concern ourselves with A7 and A8. Because A1 and to A6 were all based on what we've said in our skeleton is a misunderstanding of what the court decided. And today Mr. Wolfe didn't actually press any of those arguments. And I'll show you why he was wise not to do so. But we can deal with those briefly. And thirdly, I'll then turn to Plan B. And I intend to deal with those submissions briefly. My lord, we have set out very fully in our skeleton argument our answer to Plan B's case, insofar as it goes beyond the case of Friends of the Earth.
Yeah.
You'll know, obviously, that Mr. Wolfe has expressly distanced himself from the argument under Section 5.8 that is pursued by Plan B. We do say, with all respect to Mr. Crossland, that his arguments, insofar as they go beyond Friends of the Earth, are quite hopeless, and I'll come to why in due course.
Right.
And then, my lords, fourthly, I'm going to say a brief word at the end about what the correct test is that I say this court should apply in deciding the permission issues that arise on these claims. So, my lords, can I, with those 4
Yes.
headings, turn to my first, which is the overarching response.
Yeah.
And my lord, what I want to do is make a number of points which I say are pertinent to and relevant to both appeals. Well, the first one I deal with very briefly. Well, these are a series of rolled up applications. And, my lords, in due course, we will invite you to look very carefully at the Divisional Court's judgment as a whole in relation to climate change. So that's paragraphs, as you know, 558 through to 660, so just over 100 paragraphs, 25 pages of reasoning. But we say that that is a conspicuously thorough and careful analysis of all the climate change issues, following full argument on those issues and the consideration of an enormous amount of evidence. And we say the Divisional Court was right to refuse permission to apply for judicial review on all of these climate change issues, for the detailed reasons they gave. And I'll come to some of them, obviously, in due course, but not all of them, because I won't have time. But I do ask your lordships to read that section of judgment as a whole,
Yes.
so I know your lordships will.
Yes, of course.
Well, secondly, can I just say this? There's no disputing the importance of climate change as an issue. Climate change has been a key issue all the way through the 6.5-year process that led to the designation of the AMPS, starting with the appointment of the Airports Commission in 2012. You'll know, and it's covered in the judgment, for example, paragraph 593, don't ask you to go to it now, that the Airports Commission themselves gave very detailed consideration to carbon and climate change issues. And so important was that issue considered to be that the Airports Commission in fact contained as one of its members Professor Julia King, who was also a member of the Climate Change Committee. And my lords, again, I don't ask you to go to it now, but in due course we'll probably touch on a few paragraphs of this later on. But Miss Lowe's first witness statement, you have that in 2 places, but the relevant extracts on climate change are in the Friends of the Earth supplementary bundle, starting at page 118, and it's paragraphs 471 to 479. I don't ask you to turn it up now, but there Miss Lowe gives a very detailed account of the numerous detailed expert assessments of climate change and carbon that have been undertaken not just for the Airports Commission, but also for the department itself, going back over 6.5 years. And my lords, moreover, beyond that, the AMPS itself gives detailed consideration to climate change issues in terms of what an applicant must assess, in terms of the mitigation requirements, and in terms of what the proposed decision-making tests on climate change issues are. And can I just ask you in that regard, just to turn briefly to the judgment at paragraph 630?
Yes.
It was a useful summary to either divisional court. 630 refers to section 5, 7 and 8. It says, as Mr Marici submitted, the ANPS gave substantial consideration to matters relating to the mitigation of and adaptation to climate change. In particular, you'll see 1 expressly recognised under 5.8 must give an explanation of how the policy set out in the statement to take account of government policy relating to those matters. 2, recorded the objectives in the APF, that's the Aviation Policy Framework. That's a 2013 document, the Lordship has put it in the bundle. That is the government's current policy document on aviation and climate change. It's still current policy. That is what is proposed to be replaced in due course by the aviation strategy, which we'll also see referred to. Thirdly, noted the UK's obligations are set by the Climate Change Act. Fourthly, described how climate change matters have been assessed. Fifthly, explained how the AMPS has been informed by an assessment of whether expansion is capable of being achieved consistently with the UK's carbon obligations. And over, you'll see 6, set out what an applicant must demonstrate, address mitigatory measures, and finally, set out how matters relating to climate change will be assessed under any DCO application. And my lords, there is, we say, no challenge to the substantive policy requirements that have been set in respect of climate change. There's a complaint that we should have done our assessment of all these matters, taking into account the Paris Agreement, but there's no complaint about the detailed policy wording, about the tests that have been set in that policy. And the reason that's crucial is for a reason I'm coming to in a moment in relation to the Paris Agreement. Well, what's next, in terms of the overarching responses, the assessments that have been undertaken have been against Climate Change Act 2008. And my lords, that is so, is clear from a number of places. And can I again just give you some references? I won't take them up for now. Some of them I think you've already seen, thanks to Mr. Wolf. But my lords, first of all, there's an appendix to the AOS on carbon, and you've got it in the Friends of the Earth supplementary bundle at page 44 onwards. But in particular, when you look at that, if you look at paragraphs 9.1.6, which is on page 46, and 9.2.2, which is on page 47, and Mr. Wolf took you to that earlier, it's very clear the assessment that was undertaken was under the Climate Change Act. And my lord, that's also clear from the AMPS itself. And again, I don't ask you to go to it now. You have it in Core Bundle 5, from page 2,420 onwards.
I'm sorry, you're going to have to give
Yes.
me that again.
My lord, it's Core Bundle 5,
Yeah.
page 2,420 is where it starts.
Yes.
And my lords, can I just give you a handful of paragraph number references, some of which I'll pick up later.
Yes.
But it's 2.32, 3.61, 4.44, and 5.71 and 5.72 make it clear that the approach we took was to assess this by reference to the Climate Change
Sorry,
Act.
I need those again.
Sorry, my lord. 2.32,
Yep.
3.61,
Yep.
4.44, and then 5.71 and 5.72. My lords, the question is, why did we take that approach? Why did we assess matters under the Climate Change Act 2008? Well, my lord, first of all, because as was agreed between both ourselves and Friends of the Earth below, and this is recorded in the judgment of paragraph 642, the Climate Change Act 2008 is the legislative centrepiece of the UK's efforts to tackle climate change. That was the agreed formulation between Friends of the Earth and ourselves. It's the legislative centrepiece of UK efforts to tackle climate change. And my lords, that act itself was enacted to give effect to international obligations entered into by the UK, e.g. the Kyoto Protocol. And my lords, just to make that good, can I give you a couple of references again? I don't ask you to go to them now, but the judgment, paragraph 561 and 562, deals with the history of this matter. The Kyoto Protocol, in particular, 562, a document that was extended so that it actually runs, its commitment period runs to 2020. And my lord, that's the Kyoto Protocol, and my lord, that protocol is expressly what the Act gave effect to. And my lord, you can see that from the explanatory notes, which you've got in the Climate Change Authorities bundle.
Just a second.
Again, I won't ask you to go to them now, but I'll give you a reference. It's the Climate Change Authorities bundle, tab 2. Tab. It's tab 4. Tab 4. And it's the second page, paragraph 29. You'll see there's reference in paragraph 29 to the Kyoto Protocol. There are actually a number of other references. But this Act was expressly enacted to give effect to the Kyoto Protocol. And that was something that the judge recorded, judgment for the judges, paragraph 643 of the judgment. They recorded that the Climate Change Act was expressly entered into, made, to give effect to international obligations. And those international obligations were the Kyoto Protocol as extended. And well, just a footnote on that. When you went with a moment ago with Mr. Crossland to page 62 of his supplementary bundle, I think my Lord Justice Lindblom asked the question, when that document refers to international obligations,
Yes.
just before immediately referring to the Climate Change Act, which ones is it referring to? Well, my lords, in my submission, it's referring to the Kyoto Protocol because that's what the Climate Change Act transposed at the time we're talking about.
Yes, it may be clear somewhere in the material before us. What is the effect of the Paris Agreement on the Kyoto Protocol?
Well, my lord, it's a further agreement with obviously different obligations on the parts.
Does it
doesn't
formally?
end the Kyoto.
No, but does it formally supersede it?
Well, not that I know of. No, my lord, not that I know of.
Is that explained anywhere?
I'll have to check that, my lord.
Is that a point that you could follow
Yes,
up?
we can check that. I can't recall seeing anything on that, but I'll check.
Yes.
Well, of course, it's correct that what we didn't do was assess the ANPS against the Paris Agreement. And well, that leads to my next set of points, which are about the Paris Agreement.
So that's absolutely clear. The Secretary of State did not assess the APNS against the Paris Agreement.
Well, that is correct. Well, the dispute on the pleadings that Mr. Crossland referred to, not for the first time in these proceedings. Well, the issue there is simply a misunderstanding about whether we wholly ignored Paris, which we did not, i.e. simply forgot about it, which we did not, or whether we looked at Paris and took the view that it was not the appropriate way to assess the ANPS. And it's the latter which is our position. We didn't forget about Paris, we didn't ignore entirely Paris.
Right, well, we need to get the Secretary of State's position on this absolutely clear, so just pause for a second to let us catch up with you. What the Secretary of State did was exactly what?
My Lord, it was to consider the Paris Agreement, but to decide that it was not the appropriate basis against which to assess the ANPS. The reasons I come to.
And is that explained somewhere?
Well, that's, if you look at our amended pleading, which you were taken to, I think, several times by Mr. Crossland, so it's in volume 3. I can just find our amended details. I think Mr. Crossland, in fairness, may have taken you to one of these passages. Yes, my lord, it's paragraph 10 on page 1505. So core bundle 3. Core bundle 3, tab 9, page 1505.
1505, yes. Yes.
And my lord, that I hope, the red text encapsulates.
This is paragraph 10, is it?
My lord, yes, paragraph 10.
Well, Mr. Marici, this uses a word that you haven't so far used in your oral submissions.
Yes.
It was not relevant,
Well, my lord,
since it did not fall.
Yeah.
The latter phrase you have used again, but do you stand by the submission that it was not relevant?
I did. Yeah. So my lord, it's not that we ignored it, but we looked at it and decided it wasn't relevant or the appropriate basis to consider matters. Yeah.
Well, now that's pleadings. What about evidence?
Well, my lord, it is in the evidence as well, my lord. Can I just give
Shall
you
we
one-
find that too?
Yes, my lord. It's in. I think the best place to take is you've got the whole of Caroline Lowe's witness statement. I think now in it's Hillingdon Supplementary Bundle 6. So Hillingdon Supplementary Bundle 6.
Yes.
I'll just give you one moment just to find the reference. Yes, well, it's paragraph 458. 458. And that's page 223.2. So this is Caroline Lowe's first witness statement. She refers to the Climate Change Committee's advice in 2016, which I'll come to. So it was more ambitious than the ambition underpinning the 2050 target. The UK should not now set a new UK emissions target now, as it already has stretching targets, and achieving them will be a positive contribution to global climate change. Furthermore, and I'll come to this, it's not dealt with by either Mr. Crossland or Mr. Wolf. Furthermore, the Climate Change Committee acknowledged, in the context of separate legal action brought by Plan B against the Secretary of State for Bays, that it's possible the existing 2050 target could be consistent with the temperature stabilisation goals set out in the Paris Agreement.
I'm very sorry, Mr. Marici. I'm on page...
223.2.
No, I'm so sorry. I was on page 233.2.
So it's 223.
Yes, no, that's what I wrote down actually, but I didn't find my way there.
Well, you'll see 458, there's reference to the advice in October 16 of the Climate Change Committee.
Yes.
And then, well, if you go to the fourth line, I'll come into this in a bit more detail in a moment, but furthermore, the CCC acknowledged in the context of separate legal action brought by Plan B against the Secretary of State for Bays, that it's possible that the existing 2050 target could be consistent with the temperature stabilisation goals set out in the Paris Agreement. And I'll come to that, because we said that's an important point, as matters to the designation, i.e. the expert statutory independent body was saying it may actually be that the targets in the Act are consistent with. They may not be, but they may be. Subsequently, in establishing its carbon obligations for the purpose of assessing the impact of airport expansion, my team has followed this advice and considered existing domestic legal obligations as the correct basis for assessing the carbon impact of the project, and that it's not appropriate at this stage for the government to consider any other possible targets that could arise through the Paris Agreement. And I do need to come to that in a bit more detail, but that is the position. The statutory independent body was saying the existing targets could be consistent with the Paris Agreement.
what in effect Mr. Lowe is saying is that the Secretary of State took his lead from the Climate Change Committee and followed that line
Correct, my lord, yes.
perfectly logically.
Yes, my lord. That's what's being said. Now, my lords, with those references in place, and I hope for my lord Justice Lindblom, that makes clear what our position was about where Paris fits in.
Well, that's the relevant pleading and that's the relevant evidence.
Yes.
And the submission that follows, or perhaps it was the submission that preceded it,
Well, I think
that
it's
the Secretary of State did not assess the APNS against the Paris Agreement.
My lord, yes. And now I'm going to come to that in a little bit more detail, if I may.
Yes.
My lords, as you know, many of the grounds of judicial review that were pursued by both Plan B and Friends of the Earth below, and many of the grounds of appeal pursued before this court, do concern the Paris Agreement. And the central allegation is that the Secretary of State's assessment of the carbon and the climate change issues against the 2008 Act was unlawful because it should have been an assessment that took into account the Paris Agreement and the international obligations contained in the Paris Agreement. But, my lords, we say there are a series of fundamental obstacles that lie in the way of such an allegation being successful. And, my lord, the first of them, and it's only the first, is that the Paris Agreement, at the date of designation, was an unincorporated international agreement that had and could have no effect in domestic law. And, my lords, I do say that in large part the cases of Friends of the Earth and Plan B, which in terms of written submissions, both below and in this court, run to many hundreds of pages, are all directed, or very many of them are directed, at trying various routes to get around this first fundamental obstacle. And what they seek to do is to give effect to the Paris Agreement via the back door. And I use that word advisedly because it comes from Lord Ackner in Ex parte Brind. I don't ask you to look at it, but you've got it in the authorities bundle for climate change, tab 11, and it's page 762A. And my basic submission is it's not permissible for my learned friends to be seeking to give effect to the Paris Agreement by the back door. And you'll know that the court below, judgment 606, cited cases such as Brind and J.H. Rayner in support of that position.
Is it really the Secretary of State's submission that an unincorporated international agreement can have no effect in domestic law?
Well, there are recognised exceptions to it, as your lordship will
Yes.
know. Well, none of them are said to arise here. So, my lord, there's one in relation to ambiguous legislation, where you interpret in accordance with international law, if you can, if it's ambiguous. There's obviously an exception around where human rights complaints are in play, because under the convention, as your lordship will know, you can take into account international obligations. So there are a number of recognised exceptions. But, my lord, none of them arise here, and none of them have ever been said to arise here by the plaintiffs.
It's just a reference to Ex parte Brind.
Yeah.
I mean, that concerned the ECHR.
Yes.
And it was a decision of the House of Lords in 1990. And by 1998, there was a lot of development, even pre-HRA. There was a lot of development in relation to the ECHR. It may not all, none of it may be relevant, but I just query the breadth of the submission.
Well, my lord, the position remains, my lord, that's subject to a number of recognised exceptions. For example, interpreting ambiguous legislation in accordance with international obligations. Human rights. Subject to those exceptions.
Well, let's just, if you don't mind, you've mentioned those two. Let's just consider those. There may be others. One argument, I don't know, may be that if there's an ambiguity in the meaning of government policy, that we should construe it in a way which is consistent with international obligations.
It may be. What I'm saying to the Lordship is that argument has not been made. And if I'm wrong about that, then my own friends can show you where they made that argument.
All
below.
right. All right. Well,
Well, it's true that Mr. Crossland below pursued a number of arguments about human rights and interpretation, but he's not pursued those to the Court of Appeal.
I see.
So he pursued human rights interpretation arguments around Section 3. He did not pursue any of those in his grounds of appeal. So there is no Human Rights Act case live before your Lordships. So that exception, in my submission, is not.
I know you're going to assist us in due course in writing in relation to the WWF submissions, but they do refer, for example, to the UN Convention on the Rights of the Child.
Well, that convention, similarly, because it's unincorporated, only comes into play in the various cases that are referred to in that submission, because it's in some way being given effect through some domestic provision,
Right.
not because it's freestanding. The position still remains one of them. I do say remains good law. And my lord, in fact, it's an agreed proposition before your Lordships, because, my lord, if you look at, if you go to Core Bundle 1, tab 1, page 35, Core Bundle 1, tab 1, page 35. This is the agreed list of issues and propositions. And you'll see 18. English law is a dualist system under which international law or international treaty has directly enforced at domestic level only after it's been implemented by a national statute.
Yeah, well, the word there is direct.
Well,
That's the point.
yes, my lord.
The ECHR had lots of indirect effect, even before the Human Rights Act. Now, it may be that we don't need to go into all of this, but if the proposition is really being advanced, that it is a general principle of the law of this country that an unincorporated international agreement, which has not been incorporated, can have no effect in domestic law, I would have to respectfully disagree.
I can't say no effect law because I've accepted that there are exceptions
Yes.
to that. And one of the way it's put by the court below at 606, it's well established that English law is a dualist legal system under which international law and international treaty has legal force at domestic level only after it's been implemented by a national statute. Therefore, none of them having been incorporated, any obligation imposed on the UK law and Paris Agreement has no effect on domestic law. That's the way it was put by the court.
Well, I have to say, speaking for myself, I just think that's too good. It may not matter to the outcome of
No,
this
well,
case.
it doesn't matter the outcome of this case, but my lord, the Paris Agreement is an unincorporated international convention.
Yes.
My learned friends have to show a pathway to it being given some effect in domestic law. And my lord, the first difficulty they've got is they need a pathway because it is an unincorporated obligation. Well, I say they've got four other problems which I want to just relate to that, which my lord I think will give some context to the discussion we've just had. So the first one is this: the Climate Change Act has an inbuilt mechanism that allows for international agreements such as Paris to be given effect. My lord, that's section 2 of the Climate Change Act. And can I show you the way the court below dealt with that section? So it's paragraph 567 of the judgment below. So 567 of the judgment. The Secretary of State for BEIS has the power to amend, that's the targets in section 1, but only if it appears to him that there have been significant developments in scientific knowledge about climate change as part of the Act, or developments in European or international law or policy. And then there's the explanatory note to the Act says, as must be the case, that this power might be used in the event of a new international treaty on climate change. So, my lords, in relation to climate change agreements like Paris, Parliament explicitly took on board that these obligations might change, and it set a procedure and a process and a power to change the domestic targets to reflect new international climate change treaties. But, my lord, what's important about that is that there are a series of protections that apply and procedural routes that have to be before that can be done. And for a summary of that, can I ask you to take out our skeleton in the Plan B case? So that's core bundle 1, tab 4, page 416. I know you wanted to make that skeleton in a different place, but that's where it was in the bundles. So it's core bundle 1, tab 4, page 416. And it's paragraph 39. I should have also asked your lordships to note in the judgment of 567 Roman 3, you'll see that that process of amending the targets is also subject to a parliamentary affirmative resolution procedure under section 2.6. But if you go to paragraph 39 in our skeleton in Plan B, you'll see it says the 2008 Act provides a mechanism for the target to be amended in the light of significant developments in European or international law or policy. Moreover, it contains a number of important safeguards in this regard. Thus, before the target's amended, there's a requirement for obtaining and taking account of the advice of the Climate Change Committee. There's also a requirement to take account of representations made by other national authorities, so that's devolved administrations. Finally, the Secretary of State must determine that any amendment is appropriate, and this requires consideration to be given to, inter alia, the economic and fiscal consequences of the amendment. So it's not just about the climate change target, there's an express obligation to consider the fiscal and economic consequences of changing that target. And we say Plan B's arguments seek to render all of these safeguards nugatory and to drive up coach and horses through the statutory scheme of the Act. Because there is that process and set of procedures that need to be followed before you amend the target to deal with an international treaty like Paris. Now, my lords, what you'll have seen amongst those procedural protections was that you needed to have the advice of the Climate Change Committee before you amended the targets. And my lord, that leads to my next point, which was that at the time of designation, the extant advice of the Climate Change Committee was not to amend the target, but it was also, and I know my learned friends don't like this, but I'll show you where it's actually said this is the case, but it was also their position that the targets in the Act, the unamended targets, could be compatible with the Paris Agreement obligations. So, my lords, can I just take you to where that's dealt with in the judgment? That's the easiest way of dealing with this. 583, first of all. 583 of the judgment. My lord, you'll see that the court below says, however, the Climate Change Committee recommended the UK should not change the Climate Change Act target now, but rather focus on meeting that target. And then the court sets out a quote from a document I think you were taken to by Mr. Wolfe. This is the October 16 advice.
Give us that paragraph again.
Sorry, I'll leave the judgment, my lord. 583, my lord.
Thank you.
583. And you'll see if you go over the page, so page 608, you'll see the second paragraph on that page. However, we recommend the government does not alter the level of existing carbon budgets for the 2050 target now. And the next paragraph is one you were shown, I think, about the priority now should be robust near-term action.
Yes, we were taken to
Oh,
this.
yes, you were. And then you'll see there will be several opportunities to revisit the UK targets. And then a series of future events are listed when there would be an appropriate time to revisit this. And one of them was, I just ask you to note this, 2018, the IPPC special report on 1.5C degrees. And I'll come to that in a moment. That came out the day after the divisional court handed down judgment.
Might
Is
it
that
be,
right? No, sorry, that came out. I'll come to the correct chronology in a moment.
might it be said against you that this is all very well, but here was the Secretary of State looking at a project that was going to last 6 decades, and therefore, yes, there could be revisiting of targets, but once this had been set in stone, it would be too late.
Well, I've got a very simple answer to that, which I'm coming to in a moment, and that is the ANPS sets a decision-making test, 5.82, which is you shall not have a material impact on the government achieving the relevant carbon targets, including carbon budgets. And the divisional court held, in response to a challenge by Friends of the Earth, that the targets referred to in 5.82 mean whatever targets are in force at the date the DCO decision is made, development control, the development consent order is made. Now, that's what I argued for, and that's what the court upheld, and obviously that hasn't been challenged by effectively her. And the reality is, as we now know, of course, the Act has been amended, and the targets have been amended. So when the DCO application is made by HAL or Aurora, or whoever it may be who applies, it will be judged against targets in the Act. And those targets have now been amended to reflect Paris.
Well,
Now-
this may be very important, even fundamental. Is the effect of this submission that the Secretary of State accepts that, in effect, the Paris Agreement obligation is grafted into the APNS?
Well, it is now because of the amendment. What I'm going to say to you, my lord, is that there are three ways in which we've always said Paris was going to take into account.
Well, pause.
But yes, my lord, yes, that is. I should say yes.
Can we get the submission articulated? I've put it to you in my formulation. It might be better if we heard it from you in yours.
Well, my lord, can I just say, I agree with what your lordship said to me. I'm going to come to that in a moment because it's one of three ways. My lord, but do you want to deal with it now?
let's not come to this in a moment.
Well,
Let's
okay,
come to it
let's
now.
deal with it now. Well, just give me 1 moment, and I'll find exactly the way I want. Just give me 1 moment.
Yes.
Well, we need to look at the judgment again. It's the easiest way of doing this.
Yes.
So I'm just going to find my notes so that I can get exactly the right formulation that it was. Yes, my lord, could we look at the judgment, please? First of all, 599 to start with. 599 judgment. So this is where the court sets out the key decision-making paragraph from the ANPS, and that's 5.82. That's the paragraph you saw earlier.
Yeah.
So you'll see the quotation is any increase in carbon emissions alone is not a reason to refuse development consent, unless the increase in carbon emissions resulting from the project is so significant that it would have a material impact on the ability of the government to meet its carbon reduction targets, including carbon budgets. Now, the only carbon reduction targets that there are in domestic law are in the CCA 2008, and carbon budgets, as your lordships know, is a creature of the CCA 2008. So this is referring to not having a material impact on the ability of the government to meet the targets in the Act. And then, well, the way the court deals with this one is you'll see, go to 627, you'll see what the arguments were and what the court decided. So 627, in respect of the 2050 carbon emissions target in the CCA 2008, Mr. Wolf submitted the ANPS was internally contradictory or otherwise unclear in 6 respects. Now, pausing here, this is ground 1 below, which is not pursued before this court. And you'll see Roman 2, the concern that Mr. Wolf raised was whether the reference in 5.82 of the ANPS to carbon reduction targets refers to the targets in force at the date the ANPS was designated, or any different target in force at the date the application for development consent is returned. So that's what Mr. Wolf saying it's not clear. Is it the targets as they stand at the day the ANPS is designated, or is it the targets as they are at the date of the DCO decision? And the court answers that, my lord.
Yes.
This is the final part of the jigsaw, not appealed by anyone. So there was 631 of the judgment, 631, Roman 2. In accordance with the usual public law principles, the reference in paragraph 5.82 of the ANPS to carbon reduction targets in the context of an application for a DCO refers to the targets in force at the date of the application is returned. Mr. Marici submitted the ANPS with ambiguous appearance for effect, and we agree.
Yes.
Now, well, taking it to the final stage, we now know that the target in the Act has been amended and I'll come to the chronology in a bit more detail if I can in a moment, has been amended in the light of the Climate Change Committee's advice to give effect to the obligations under the Paris Agreement. And there's no complaint before this court, nor could there be, that the change that was made to the Climate Change Act in that order that you were shown by Mr. Wolf fails to transpose properly the Paris Agreement. That's not a claim that could be brought in these proceedings, but it's not something that's been raised. And well, therefore, ultimately, this project, before it ever obtains a consent, is going to have to be assessed against current targets. And those current targets have been amended to reflect Paris.
I'm just pausing. The project will have to be assessed under paragraph 582
582.
in accordance with
The current targets in the 2008 Act.
the current targets
And those targets have been amended to give effect, as we shall see, to the Paris Agreement. Now, well, can I just say this? That,
just pause, sorry, before you say this, whatever it may be, this means also, does it, that if, for the sake of argument, the UK government were to enter into a further international obligation, more stringent still than Paris, that too would, as it were, automatically be grafted into the test applicable through paragraph 582.
it would want if it was transposed through section 2.
Oh, yes.
Changing the target.
Yes, I should have added that.
Yes, but subject to that, my lord, yes. Well, that does link to the point I was going to make, the further point I was going to make. I need to come back to this in a little bit more detail. But, well, it's true that the amendment to the 2008 Climate Change Act, that amendment obviously postdates the judgment below, it postdates designation. It's a post-designation event. But it was always our case that this was one of the ways in which, if there was a change to the legislation to give effect to the Paris Agreement, that this matter could be taken into account before a new runway ever got permission. So although I'm relying on ex post facto events in this regard, I'm only relying on them because it's always been part of our case that one of the reasons we didn't have to speculate at the AMPS stage about how our domestic targets might change in order to give effect to Paris, if at all, because of course the Climate Change Committee's advice I'm coming to was that it might actually be that the current targets were consistent with Paris. But the reality is that we always made a key part of our case to say that this is one of the ways, and there are a number of others I'm coming to, that the Paris Agreement would be given effect to, such that it wasn't necessary or appropriate or relevant for us to be speculating about the impact of Paris on our domestic obligations at a time where that had not been resolved.
Right.
I'm going to develop that in a bit more detail.
Well, before you do, it can then be recorded, can it, as the government's position before this court that the Paris Agreement obligations apply to the project through the normal operation of paragraph 582 of the APNS.
Correct one. As I said, I'm going to come to some other ways in which it will also bind, but that will do for now.
Yes.
So, can I just go back to when we went to look at this material? I was dealing with the fact there were a number of think that counts as 4 additional hurdles
Yes.
beyond simply the fact that this is an unincorporated international obligation. And the first one, which I think was the one I was still on at that point, was that there's an inbuilt mechanism within the 2008 Act to deal with changes and new treaties dealing with climate change. That was section 2. And the point I was coming to next, the second point, which I think started to head towards, was that the advice of the Climate Change Committee at the date of designation of the NPS was that the targets in the Climate Change Act could be compatible with Paris. Now, obviously, that's not how things have turned out, because subsequently they have advised that there should be an amendment, and the amendment was made. But at the date of designation, and I'll show you where this comes from, their advice was that they could be compatible. So if we go back to the judgment 583, I was showing your lordships in 583. You remember I was showing your lordships the October 16 advice, my lords, which is quoted in 5.583 of the judgment. And you'll see at the very end of the quotation on page 608, we will advise, and this is the Climate Change Committee, on whether to set a new long-term target or to tighten the carbon budgets, as and when these events or any others give rise to significant developments. And one of those events, which I started to note for now, was the 2018 Intergovernmental Panel on Climate Change's advice, which came out post-designation. I'll show you when. And then, well, 584 is important for the submission I made. Plan B pressed the Secretary of State for days to revise the 2050 carbon target under the Climate Change Act on the basis that following the Paris Agreement he was obliged to do so. So Plan B brought separate proceedings as your lordships know, seeking to argue that the Secretary of State for days was obliged, back in, I think these proceedings started in 2017, obliged to amend the Act then to reflect the Paris Agreement. It goes on, the Secretary of State refused. Plan B and 11 other claimants issued proceedings, and in response to the claimant's reply to the summary draft defence, 7th 10th April, the Climate Change Committee said, the Climate Change Committee recommended no change to the existing UK 2050 target at that time, October 16, not because a more ambitious target was infeasible, but rather because the existing UK target was potentially consistent with more ambitious global temperature targets, including that in the Paris Agreement. So that's April 18, that was the most up-to-date statement from the Climate Change Committee prior to designation, and they were saying it was possible, potentially consistent, that the targets would never have to be changed, not have to be changed. And we'll see that further, 585, following refusal of permission by Mr. Justice Lang, Mr. Justice Upson refused permission at an oral hearing, finding, and then Roman 3, the Climate Change Committee's advice, as of October 2016, was that the existing 2050 target is potentially consistent with a wide range of temperature outcomes and was compatible with the Paris Agreement. See paragraph 25. Now, well, we don't have to look at it, but you have actually got that judgment in the bundle. It's in the Climate Change Authorities bundle. If you want to look at it in due course, tab 31. But the Climate Change Committee appeared and were represented at that hearing, and that was their position, that the target was potentially consistent and therefore might not need to change. And well, that takes me on to one other reference in the judgment, 610 in the judgment.
Yes.
610. The most recent formally expressed view of the CCC is that the current target in section 1 of the Act is potentially compatible with the ambition of the Paris Agreement to limit temperature rise to 1.5 and well below 2, i.e. that impression could be attained, even if the current target is maintained, and therefore one possible rational response to the Paris Agreement is to retain the current CCA 2008 targets at least for the time being. So that was the position as at the date of designation. And I say it's another reason why there is a fundamental hurdle in the way of my learned friend's submissions, because section 2 is the mechanism for giving effect to Paris. You have to consult with the Climate Change Committee before you do it, and the Climate Change Committee's view at the time of designation was was that it was possible, that it was consistent to leave those targets in place.
It might be asked, what was the government policy at the time of designation? Was it to follow Paris, or was it to follow whatever advice it was getting from the Climate Change Committee?
Well, what the government had said, and I'll show you this in a moment, was they were going to wait for the advice of the IPCC, which we saw mentioned. If you go back to 583 in judgment, you'll remember 583, page 608, the Climate Change Committee itself said there are some future events that might well trigger us looking again at whether the target should change in relation to Paris. One of them was the Intergovernmental Panel on Climate Change. And what the government said was that when that report was received in the future, and I think it was October 18, October 18, at that point they would seek the advice again of the Climate Change Committee as to whether the target should be changed or not. So the way it was set up was, and I think the Climate Change Committee actually invited the government and said, you should invite us to advise once that IPCC report is available, and at that point we will look again to see what you should do. So the government's policy in terms of implementation was to do, not to change the Act, because that was the advice the Climate Change Committee had given it as of October 16, and as of April 18 for that matter. But when the IPCC reported, it would ask the Climate Change Committee again to advise as to whether further action needed to be taken. And that is what happened. They invited the committee to advise, and the committee advised on the 2nd of May, which was the day after the Divisional Court handed down its judgment. And then a month later, as we've seen, in response to that, the government amended the target, because that was the advice the Climate Change Committee gave. So, my lord, the policy was, yes, we were committed to the Paris Agreement. We had ratified the Paris Agreement. There's no question about that. But there was a question about how and when you give effect to its obligations. And the government's policy on that was to, as the statute indeed requires, for it to seek the advice of the Climate Change Committee. Its advice to date of designation was not to change the target to reflect Paris, but obviously subsequently it advised differently, and that's all happened.
The advice given, do we have the advice given by the committee in
You've
May?
got an extract of it, my lord, yes, in one moment. I think it's Plan B's, it's Plan B, Supplementary Bundle, page 87.
Yeah.
My lord, I think he's got the 86 next, so he's got the forward only, I think, but I think it gives you a sense of.
Yes, we were looking at this a little earlier.
So I think at page 87.
Well, were we? I'm not sure.
I'm not sure we were, my lord.
I'm not sure we were. So this was the advice given by the Climate Change Committee.
This is obviously just the forward to it, but it does give you a sense of what the advice is. So you'll see from the first line in this report, the committee recommends a new emissions target for the UK, net zero by 2050. And our recommendation emerges from extensive evidence presented here, etc. And then you've seen refers to the IPCC special report on global warming. So that was the report that came out in October 18, and which it was always going to be the trigger for further advice. And then also, you'll see also at the bottom of the page, all this rests however on more than just a new target, and there are various other things said. But this is the forward one. If you wanted to see more, I'm sure we could provide it, but that's the advice that was provided on the 2nd of May 2019, and led the next month to the order, which you've got in the authorities bundle, that amended section 1 of the Climate Change Act. And this was all, of course, and you can see it from that document, reflecting the Paris Agreement. That's what drove all of this. So, my lords, the position, in summary, my lords, is that there's a bespoke mechanism for amending our domestic targets when there's a new international climate change treaty in place, like Paris, but it has set procedures. The government followed those, and indeed at the time of designation, the advice from the Climate Change Committee, which is an essential element of this procedure change, was don't change the target now. It might be compatible with the greater ambition of the Paris Agreement. Well, that's the second of my 4 points. Well, can I deal with the third of these? And well, that requires us to look at the Planning Act, which is in the main authorities bundle, volume 1, tab 1. And I'd like you to look at section 104 of the Planning Act. I'm afraid these extracts are not paginated, so we'll just have to flick through to find 104.
Right.
They are paginated, but they're all page 1.
Yes, well, that's true, my lord. They are all paginated, page 1, which is very useful. So, my lord, if you find 104, this is the key statutory provision for the determination of development consent orders where there's a relevant national policy statement in place. So, section 104 is what will govern the decision making in relation to any application for development consent by Hal or Laura, whoever it may be under the NPS. And my lords, what I want to draw attention to is a number of provisions. We'll come to those in a bit more detail. But my lord, if you look at 104.4, I should probably give you the context. If you look at sub 1 first of all, this section applies in relation to an application for an order granting development consent if a national policy statement has been made in relation to the development of the description to which the application relates. And then 2 says, in deciding the application, the Secretary of State must have regard to, and I'm going to come back to some of these points in a moment, but 3, the Secretary of State must decide the application in accordance with the NPS, except to the extent that one or more of subsections 4 to 8 applies. And then model 4 is the relevant one that I want to draw your attention to. This subsection applies if the Secretary of State is satisfied that deciding the application in accordance with any relevant national policy statement would lead to the UK being in breach of any of its international obligations. Now, well, that must mean unincorporated international obligations, because if you look at sub 5 and sub 6, they are separate exceptions for when the Secretary of State would be in breach of statutory duty, or there would be any breach, unlawfulness, by reason of an enactment. So Parliament gave express consideration in this Act to when unincorporated international obligations could bite, and they decided that they could bite at the VCO stage. And what is absent, my lord, is any similar requirement to consider unincorporated international obligations in the section of this Act that deals with national policy statements themselves.
This doesn't mean, does it, subsection 4, that the Secretary of State may not still decide the application in accordance
It doesn't mean that, but obviously
with the national policy statement.
No.
It gives him pause,
it gives him pause.
or at least it releases him from the obligation,
Yes.
which is otherwise binding on him under subsection
Exactly.
3.
Without this, he's obliged to decide it in accordance with the NPS.
This gives him a discretion.
This gives him a discretion not to do so.
So he would still be, would he, at liberty to decide it contrary to an international obligation and in accordance with the NPS?
He would.
That's what Parliament has decided.
Well, that would seem to be the way the statute works, yes.
Yes.
And well, that leads to my 4th point, which is that, well, the Paris Agreement itself, prior to its incorporation and giving effect, as it now has been through the changes of the targets, the Paris Agreement imposes no obligation on any individual state to limit global temperatures or to implement the objective in any particular way. It gives a discretion to those who signed it to take national measures to implement it. And well, the reason that's important, and the reason I link it to section 104, is that when I raised section 104 below, I want to show you what Mr. Wolf's response was to to that and what the court said about it subsequently. So could we go in the Friends of the Earth supplementary bundle, please? Friends of the Earth supplementary bundle to page 232. You should have 4 pages from the transcript on one page. And if you look at page 98, the very bottom, Mr. Justice Holgate asks a question to Mr. Wolf. Can I ask one question? It arises under ground 2. You mentioned the DCO process in section 104.4. It's about page 82 of the transcript. We'll come to read about that. You said the Paris Agreement does not contain the sort of obligations which would bite under section 104.4. You didn't, according to my notes, say why. Can you tell us, please, why the Paris Agreement doesn't contain obligations of the kind that would bite under section 144? Mr. Wolf, because it sets objectives which, as it were, the world is to move towards, or signatories at least of the Paris Agreement are to move towards. It is hard to see how, at the DCO stage, one could be saying in relation to the UK's commitment, or lack of it to that there is a breach of the international obligation by the UK. That is not in. And then Mr. Justice Holgate says, so another way of putting that point is to say it requires translation of the national level by all the signatories to the agreement, international figures, targets, national targets. Mr. Wolf, yes it does. And in international figures, and our Climate Change Act provides a framework for doing it, but it is not the only framework. So, my Lord, what Mr. Wolf was saying, and quite rightly so, was the problem with the Paris Agreement is that it doesn't actually impose an obligation on the state that you can give effect to in a domestic level way, because it needs translation, it needs decisions to be made by the states. And my Lord, the judges below, can I just show you what they said about
Just
it?
before you do that,
Yes,
you've put your copy of this away. But what Mr. Wolf went on to say was that is why our argument on 10.3 is so important.
My Lord, yes he did, my Lord, but the argument comes back to bite him on 10.3 as well, because, my Lord, and this is what the court, I'll show you in a moment what the court said, what the court says is, because this is not the kind of international obligation that can actually bite without national translation of it, then it can't also be something that you have to have regard to under section 10.3, because in assessing the ANPS, you can't reach a view about its compliance with a global target until you know what the UK is doing as part of its contribution to meeting that global target. So if I show you what the judges, well, thank you. If I show you what the judges said about that, could we start with 607 judgment? 607. In any event, as we've described, whilst expressing international objectives, notably to hold the increase in the global average temperature to well below 2 degrees above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 above pre-industrial levels, the Paris Agreement imposes no obligation upon any individual state to limit global temperatures or to implement the objective in any particular way. Well, I think that is almost word for word what Mr. Wolf said in the transcript. It expresses global objectives and aspirations in relation, in respect of national contributions to meet those objectives, and it obliges each state party to prepare, communicate, and maintain successive nationally determined contributions that it intends to achieve. Parties are required to pursue domestic mitigation measures with the aim of achieving the objectives and ensure they meet the requirement for successive nationally determined contributions to be progressive, Article 4. But it clearly recognises that the action to be taken in terms of contributions to the global carbon reduction will be nationally determined in the light of different national circumstances, and that in that determination of national contributions, economic and social, as well as purely environmental factors, and the consideration of how other states are proposing to contribute, will or may play a proper part it's clearly recognised on the face of the Paris Agreement that the assessment of the appropriate contribution will be complex and a matter of high-level policy for the national government. And then my lords, 631, the judgment, 631, 3, so sub Roman 3. And my lords, about 5 lines down, I think some of this was read by Mr. Wolf read the first few lines, but he didn't read the next part. So you'll see, the third line down, this is the AMPS, cannot refer to international targets such as objectives set by the Paris Agreement because, for the reasons we've given above, the Paris Agreement does not specify any carbon reduction target. It does not impose any obligation on the UK government to meet any carbon reduction target, or indeed any other target or temperature objective. So it's just not the kind of international obligation that can bind at the domestic level without the national implementation of that. And well, there's one other reference, if I may, to the court judgment, 146 in the judgment. This is actually in the section where the court is dealing with standard of review. And well, there's about 6 lines down in 146. As we explained below, the Paris Agreement raises a policy issue for the government and for Parliament to address, namely the future carbon reduction target for the UK as its contribution to the revised Paris Agreement target to address, namely the future carbon reduction target for the UK as its contribution to the revised Paris Agreement target expressed solely in global terms. This is plainly a policy matter at a high strategic level which engages the widest possible range of economic and social considerations in the UK. Well, the reality is that the claims that are before this court sought to preempt these judgments and require, in some unspecified way, that regard be had to this international global target that didn't have a direct application, couldn't be directly applied domestically. That's what these claims are trying to do, to preempt those judgments and to require regard to be had to this global target. And we say simply that's something that can't be done because you can't apply the Paris Agreement directly at a national level without these complex decisions about how it's going to be done. And well, that's where Mr. Crosland, in all his submissions, goes wrong, because he refers to numerous statements of the government saying they are committed to Paris. But in all those same statements, it says what the government has not decided is how to do it. There's a how question, there's also a when question, but the how question is raised. And that's what Mr. Crosland misses each time he reads these documents. He doesn't see that point. But that's, we say, a key point as to where, and that's what I should say, you'll see from the Divisional Court's reasoning, it's a key element of the Divisional Court's reasoning about why the Secretary of State was right not to try and have regard to the Paris Agreement before that agreement had been implemented into national law. Their view was it's not really something you could even sensibly do. And in my submission they were right for the reasons they gave.
But although the judgment says in 607 at the bottom this is complex and a matter of high policy, and you made your submissions about difficulty of implementation, the fundamental base plate of Paris was very simple and clear: reduction to 1.5%. The question may be put to you, why, despite your submission, should it simply be ignored?
Well, because
of difficulties in implementation.
Well, two reasons. One is the advice of the Climate Change Committee at the relevant time. Their most up-to-date formal view was that the target in our own domestic act was potentially consistent, i.e. it might not need to be changed at all. That's point one. But point two is how it was going to change was completely uncertain and undecided at that time. Therefore, it wasn't possible in any meaningful way to assess matters against the Paris Agreement because those decisions had to be taken. Well, I should say there's a third element to this, which comes to the point that I took your lordship to a moment ago, which I'm coming back to, which is it was always the government's view that there were other ways in which the Paris Agreement would come into play in relation to this project which is being set up in the AMPS. For example, as we've seen, under 5.82, if there's a change in the targets, it's those new targets that will apply at the DCF stage.
Yes, I mean, we're considering two things, aren't we? We're considering, if you like, the prior stage, the very initial stage of the whole exercise, before the ANPS is framed,
Yes.
whether the Paris Agreement is a consideration that ought to be taken into account. Qua Paris Agreement, it is what it is. Its obligations are of the nature you describe.
Yes.
That's the first question. The second question is whether, if you leave it out of account at that stage, it still has a place in the whole process, seen as a totality with the subsequent decision-making process on a particular project. So there are two stages to this.
There are.
As I understand your submissions, the submissions you've been making to us this afternoon have been directed to the first stage.
They have been directed to the first stage. I'm actually coming to the second stage now. Yes, if I have got.
Now or in the morning?
My lords, I'm not going to do it in that time probably, so I think probably tomorrow.
Give us the highlight.
Well, my lord, well, my lords, the highlights. There's three points, my lord, three headlines. One of them you've already had, my lord, which is paragraph 5.82 of the ANPS, which obviously applies to any amended obligations in the Act. So that's one way in which the Paris Agreement will come to be relevant, is relevant in the assessment of the DCO application, because the targets have been amended, and that's what 5.82 requires you to do. Well, the second is that I'm going to take you back to section 104, because there are several other ways in which, under section 104, developments in climate change policy and science can be taken into account under section 104. And the reason I say and science is because obviously Mr. Wolf's points are not just Paris, he's also got this non-CO2 point. And while that was dealt with by the judges below under the heading of changing science, and we'll see that they didn't ignore it, as Mr. Wolf suggests, but they actually did deal with it that way. So that's the second one. There's other ways in which 104 can require future development to come into play. And then the third one, the final one, is to look at section 6 of the Planning Act. And section 6 is the act, is the provision of the act you were shown by Mr. Wolf that allows for reviews of ANPSs where there's been a significant change in the circumstances. And I simply rely on that because there is something in the court's judgment below, but also in other cases, including one case, one decision of Lord Justice Sales in this context, where what was said was that if you're concerned about things that might change in the future, the way this act envisages that being dealt with is by conducting a review of the ANPS. So it's another way in which, if in the future things change because of Paris, there is a way of dealing with that under the Act. That's my sort of third and final point. I need to explore that one in a little bit more detail just to show you how it fits in. The first two are 5.82, section 104, and then finally section 6. So those are the headlines. I'll come back to it.
Thank you very much. Thank you.
Well, I've got an hour and a quarter left tomorrow. I have quite a few other things to cover in terms of submissions that are made today. In order to get through it in time, I am going to do at least a note of references for your lordship, because obviously one of the things that takes time is me reading out these references. So
Yes.
I will certainly do that.
Yes, now that will help us. We commend all counsel who've been on their feet today, all advocates who've been on their feet today, for their very clear submissions, and not least for adhering to the timetable that was agreed before the hearing. Grateful to you, thank you. So 10:30.